Decision podcasts are brought to you by the New York Prosecutors Training Institute. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People v. Weinstein decided on April 25, 2024. Rivera, J. Every person accused of a crime is constitutionally presumed innocent and entitled to a fair trial and the opportunity to present a defense. See U.S. Const. Amend 6 and 14. Nye Const. Art. I. Section 6. Estelle v. Williams, the right to a fair trial is a fundamental liberty secured by the 14th Amendment and ta presumption of innocence, although not articulated in the Constitution, is a basic component of a fair trial under our system of criminal justice. Crane Eve Guy Comches of the rooted directly in the due process Casaresimin. ALEU, or in the compulsory process or confrontation clauses of the Sixth Amendment. The Constitution guarantees criminal defendants a meaningful opportunity to present a complete defense. Quoting California v. Trombetta, under our system of justice, the accused has a right to be held to account only for the crime charged and, thus, allegations of prior bad acts may not be admitted against them for the sole purpose of establishing their propensity for criminality. See People v. Mullinux. Nor may the prosecution use prior convictions or proof of the prior commission of specific criminal, vicious, or immoral acts, other than to impeach the accused's credibility. People v. Sandoval. It is our solemn duty to diligently guard these rights regardless of the crime charged, the reputation of the accused, or the pressure to convict. See Boyd v. United States. It is the duty of courts to be watchful for the constitutional rights of the citizen, and against any stealthy encroachments thereon. Defendant was convicted by a jury for various sexual crimes against 3 named complainants and, on appeal, claims that he was judged, not on the conduct for which he was indicted, but on irrelevant, prejudicial, and untested allegations of prior bad acts. We conclude that the trial court erroneously admitted testimony of uncharged, alleged prior sexual acts against persons other than the complainants of the underlying crimes, because that testimony served no material non-propensity purpose. The court compounded that error when it ruled that defendant, who had no criminal history, could be cross-examined about those allegations as well as numerous allegations of misconduct that portrayed defendant in a highly prejudicial light. The synergistic effect of these errors was not harmless. The only evidence against defendant was the complainant's testimony, and the result of the court's rulings, on the one hand, was to bolster their credibility and diminish defendant's character before the jury. On the other hand, the threat of a cross-examination highlighting these untested allegations undermined defendant's right to testify. The remedy for these egregious errors is a new trial. However, we reject defendant's claim that the third-degree rape prosecution was untimely under 30.10 because, as a New York resident, his brief absences from the state before the authorities were aware of the crime did not toll the limitations period. Defendant's argument finds no support in the statutory text. Therefore, the trial court properly discounted the days defendant was continuously outside the state and correctly held that the prosecution was not time-barred. Defendant may be retried on this count. Defendant Harvey Weinstein was charged with 1 count of first-degree criminal sexual act under Penal Law Section 130.51, based on allegations that, on July 10, 2006, defendant forcibly performed oral sex on complainant A in his New York City apartment. 1 count of first-degree rape under Penal Law Section 130.3 under Penal Law, Styrin Pyder Dimredi Fine, and 2 counts of predatory sexual assault under Penal Law Section 130.95 based on allegations that defendant engaged in the attacks against complainants A and B after having raped complainant C in either 1993 or 1994. The court denied defendant's motion to dismiss the third-degree rape charge as untimely, concluding that under CPLA 30.10(4) AIE, the statute of limitations was properly told during the time defendant was continuously outside New York State. Defendant was tried before a single jury on all counts. At the time of the alleged crimes and at the time of the trial, defendant was a well-known, powerful man within the entertainment industry, having produced several award-winning and highly profitable films. The prosecution's theory of the case was that defendant abused his power to take advantage of aspiring female actors, like complainants, to coerce them into unwanted sexual encounters. According to the prosecution, The quid pro quo of assisting them with their careers in exchange for sexual favors on demand was both common behavior and a well-known secret throughout the film industry. When his victims resisted his sexual demands, the prosecution argued defendant used force. Traumatized by defendant's sexual assaults and fearing retaliation, the complainants never reported the attacks and continued personal and professional relationships with him for years afterwards. Before trial, the court granted the prosecution's application to admit certain testimony of uncharged crimes and miscellaneous bad acts as an exception to the Molyneux rule, prohibiting such evidence to establish defendant's intent and his understanding of the complainant's lack of consent. Thus, complainant B could testify about defendant's uncharged sexual assaults against her before and after the charged rape and her awareness of defendant's abusive and threatening behavior, and 3 other women, the Molyneux witnesses, could testify regarding defendant's sexual misconduct towards them years before and after the charged offenses involving complainants A and B. The court also granted, in large part, over defendant's objection, the prosecution's Sandoval application to cross-examine defendant on a broad range of uncharged bad acts should he testify. Pursuant to this ruling, the prosecution was permitted to ask about, for example, whether defendant directed a witness to lie to defendant's wife, filed an application for a passport using a friend's social security number, told a woman he could harm her professionally but could also offer her a book publishing opportunity, used his entertainment company's budget for personal cost, drew from a busyness and attainment in a stimulant, told a private intelligence firm to manipulate or lie to people, scheduled a business meeting in 2012 with a woman under false pretenses, induced executives to lie on his behalf, made threats and committed acts of violence against people who worked for him, and danded a colleague by the side of the road in a foreign country, physically attacked his brother, threatened a colleague by the side of Prarij in a Turid and Shahid. The court also permitted the prosecution to cross-examine defendant about the details of the sexual assault allegations described by the Molyneux witnesses during the prosecution's case. After the court denied defendant's motion to dismiss the third-degree rape charge as time-barred, the case proceeded to trial. Complainant testified that she had known defendant since 2004 when she met him in a hotel room to discuss a job opportunity she later accepted, during which he made comments about her body and asked her for a massage, which she refused. Sometime later, defendant unsuccessfully propositioned her to travel abroad with him and, at one point, barged into her apartment. 2 years later, defendant invited complainant A to a film premiere in Los Angeles and, the day before she was to travel, asked her to his New York hotel room. When she arrived, defendant lunged at her to kiss her. She said, "No, no, no," and tried to push him away, but defendant pulled her back towards him and kissed and fondled her. She attempted to flee, but defendant used his weight and his body to lead her into the bedroom, where he pushed her with his body until she fell backward onto the bed. She recalled that she tried several times to get up, but each time defendant pushed her back. She kicked and pushed to get away, but defendant held her arms by her wrists and laid on top of her, holding her down. After she gave up struggling, he forced himself on her orally. After she returned to New York, defendant again asked her to his hotel room where, according to complainant A, he grabbed her by the arm and led her straight towards the bed. She testified that she laid there and didn't resist physically as defendant had intercourse with her while calling her derogatory names. Despite feeling embarrassed and unsure of how to deal with it, complainant maintained a professional connection with defendant because she wanted a job. Over the next 2.5 years, she met defendant in London to pitch him an idea and sent him friendly emails thanking him for his support and signing off with, "Lots of love." A. Complainant B testified that she wanted to act since childhood and first met defendant at a party in February 2013, where defendant expressed interest in her career. Defendant expressed interest in her career. Defendant subsequently took her to exclusive Academy Awards parties and dinners. Later that same month, defendant invited complainant B to his hotel room in Los Angeles, California, and, when she entered, grabbed both of her arms and tried to kiss her like crazy and then sexually assaulted her. Afterwards, she decided to initiate a real relationship with defendant and saw him regularly, engaging in consensual oral sex with him. Complainant B testified that, during their relationship, defendant attempted to persuade her to have a sexual interaction with himself and another actress, but both women were uncomfortable and complainant B left the room. During the defense's cross-examination of complainant B, The prosecution successfully moved to present the other woman's testimony about this incident, and her testimony corroborated Complainant B's description. Complainant B also testified that, in March 2013, she and some friends met defendant for breakfast in a Manhattan hotel. Defendant arrived early and booked a room. Once in the room, Complainant B argued with defendant, saying that they did not have time for anything sexual. She stated that she twice tried to leave, but defendant blocked her by putting his hand on the door above her head and slamming it shut. Defendant told her to undress in a sharp and angry tone, and when she hesitated, defendant grabbed her hand and held it to force her to undress. When Complainant B was completely naked, defendant told her to lie down on the bed and, after disrobing in the bathroom, he got on top and had intercourse with her. Complainant B explained that she maintained a friendly relationship with defendant afterwards out of fear for her personal safety and professional prospects. When defendant discovered she was dating another actor, he told her, "You owe me one more time," and dragged her into his Los Angeles hotel room. Complainant B pleaded no, please no, but defendant lunged at her and ripped her pants off, leaving scratches on both legs. He then forcibly performed oral sex on her, forced her to reciprocate, and forcibly had intercourse with her. She maintained a friendly relationship with defendant during the years that followed, which included consensual sexual relations and emails telling defendant that she loved him. Complainant C, an established Hollywood actor, testified that she met defendant during the early 1990 seconds, and that he played a role in her becoming addicted to drugs at that time. Sometime during the 1993-1994 winter, they had dinner together and he left her at her Manhattan apartment. A half hour later he returned, pushed his way inside, grabbed her near the collar, led her into the bedroom, and shoved her on the bed. Complainant C explained that she was punching him and kicking him, but defendant restrained her hands above her head and raped her while she was trying to fight, but she could not fight anymore because he had her hands locked. Complainant C also testified that, later in 1994, defendant repeatedly called her and sent cars to her hotel room while the two were in London, and the following year, tricked her into agreeing to make another film that she did not know as producing. The three Molyneux witnesses testified about defendant's individual unwanted sexual advances towards them. Witness 1 stated that she met defendant in 2004 at a Manhattan nightclub while she was working as an actor, and defendant said he could help her career. Sometime in 2004 or 2005, she met defendant in a hotel room for a networking event. Defendant led her to the bedroom, where he suddenly put his hand up her skirt and tried to put his hand inside her vagina and apologized when she pulled away. A few weeks later, she agreed to meet defendant at another hotel where, clothed in a bathrobe, he told her that he would sign contracts for her to work only if she had sex with him and his assistant, but then told her he was joking and that she would never make it in this business unless she changed her attitude. Witness 2 testified that she met defendant during the summer of 2005 while she was an aspiring actor working as a cocktail server at a Manhattan lounge. Defendant gave her his contact information and then, minutes later, grabbed her by the arm and led her upstairs to a deserted terrace, where he pulled her so that she was facing him and masturbated. A week or two later, Witness 2 was invited to read for a part at defendant's production company, but, while in the waiting room, was told that defendant wanted to see her at his apartment. When she arrived, defendant grabbed her arms and threw her on his bed before removing her clothes and having intercourse with her as she just froze and looked off. Witness 2 explained that defendant was a heavy man who weighed her down. Defendant then drove Witness 2 back to the studio, but she was not allowed to audition and did not get the part. Witness 3 testified that she met defendant in February 2013 in Los Angeles, where she was working as an actor. Another actor friend of hers invited her to a Beverly Hills hotel to discuss a film script. Defendant invited the two to continue the conversation inside his room and, once inside, led Witness 3 into a bathroom as the friend closed the door behind them. She then testified in detail about how defendant undressed as she nervously laughed before he pulled down her dress and masturbated, despite her protests, while grasping her breast and asking her breast and asking her how else he could act. The prosecution admitted photographs of the dress she had been wearing into evidence. Following the testimonies of these three Molyneux witnesses, the trial court instructed the jury that this evidence must not be considered for the purpose of proving that the defendant had a propensity or predisposition to commit the crimes charged. The court further explained that the prosecution introduced the Molyneux witnesses to the jurors for their consideration on the question of whether the defendant intended to engage in the sexual acts and whether each of the complaining witnesses consented. During the final charge to the jury, The court reiterated that the testimonies of the Molyneux witnesses was offered for its consideration on the issues of forcible compulsion and lack of consent. The prosecution also presented testimony from a forensic psychiatrist and an expert on rape trauma syndrome. She described how sexual assault victims may behave in ways towards their attackers that persons unfamiliar with the syndrome might consider counterintuitive. She attempted to dispel certain rape myths, including that most rapes are committed by strangers, and that credible victims promptly report attacks and discontinue relationships with their attackers. She further testified that traumatic events narrow the brain's ability to focus on specific details, yielding clearer memories of such events. Defendant did not testify on his behalf, but during cross-examination of the complainants and during closing argument, defense counsel questioned the credibility of the complainants by highlighting their continued personal and professional relationships with defendant and complainant B's admission that she continued a consensual sexual relationship with defendant after her alleged March 2013 rape. Defendant also presented testimony, as limited by the court, from a psychologist specializing in human memory who testified that exposure to falsehoods regarding a traumatic incident leads to the formation of false memories, which themselves could fade with time. She also testified that asking a traumatized person to remember the trauma could cause additional stress that further impairs their memory of the event. The jury acquitted defendant of both counts of predatory sexual assault and the first-degree rape count, and convicted him of first-degree criminal sexual act for the July 10, 2006 complainant A charge and third-degree rape for the March 18, 2013 complainant B charge. The court sentenced defendant to consecutive terms on each count, an aggregate 23 years in prison, followed by 5 years post-release supervision. The appellate division affirmed. The court concluded, as relevant here, that the tolling provisions of CPLA 30.10(4) applied in the third-degree rape prosecution was timely commenced. The court also concluded that the trial court properly admitted the Molyneux testimonies to show that defendant's sole interest in the complainants was sexual, and their consent was irrelevant to him because, during his prior experiences with the Molyneux witnesses he had, as he had done with complainants, expressed an interest in helping them, and yet they reacted negatively to defendant's advances. This demonstrated to the jury that defendant knew that a woman would not consent to having sex with him merely as a quid pro quo for the assistance he could provide them in their professional career. The court observed that the amount of Sandoval material on which the trial court permitted the prosecution to cross-examine defendant had he testified was unquestionably large, but that all of the material allowed by the court was unquestionably relevant because allegations that defendant solicited lies or deception went directly to his credibility and his abusive or violent behavior in business settings or did a section CHDT and his abusive or violent behavior in business its. A judge of this court granted defendant leave to appeal. Defendant claims that his third-degree rape conviction should be reversed because the prosecution was commenced beyond CPLA 30.10(2), BE's then applicable 5-year statute of limitations, CCPL former 30.10(2)B. The prosecution of this count was undisputedly commenced 69 days after expiration of that limitations period, but the prosecution argued that CPL 30.10(4)A told certain periods when defendant was not in New York. Defendant claims the tolling provision does not apply here because it applies only to non-residents. He was not continuously outside the state within the meaning of the statute, and, in any case, CPLA 30.10. The plain text of a statute is the best indicator of legislative intent, and thus the proper starting place in discerning its meaning, Town of Irondequoit v. County of Monroe. See also People v. Cahill T. He plain meaning of the statutory text is the best evidence of legislative intent and, in fact, the only authoritative basis for interpretation. The court has eschewed efforts to rewrite the statute to achieve what a court or advocate perceives to be a better outcome, People v. Anonymous, and has cautioned that, where a statute describes the particular situations in which it is to apply, and no qualifying exception is added, an irrefutable inference must be drawn that what is omitted or not included was intended to be omitted or excluded or empted or excluded or admitted or netted omitted or excluded. Of probation, internal quotation marks omitted. See also McKinney's Cons Laws of Nye, Book 1, Statutes, Section 363, and the cases cited therein. A court cannot amend a statute by inserting words that are not there, nor will a court read into a statute a provision which the legislature did not see fit to enact. Court cannot, by implication, read or supply in a statute a provision which it is reasonable to suppose the legislature intentionally omitted. Section 30.10(4)(a) provides in pertinent part that in calculating the time limitation applicable to commencement of a criminal action, the time period shall not include any period following the commission of the offense during which, i.e., the defendant was continuously outside this state or, i.e., whereabouts of the defendant was continuously outside this state or, i.e., the whereabouts of the defendant were continuously unknown and continuously unknown, and the resters of hiding was. Nowhere does this provision distinguish between residents and non-residents, and we cannot read into the statute a limitation not adopted by the legislature. See matter of Alonzo M.A. If the legislature intended this tolling provision to apply only to non-residents or that courts should factor residency into a tolling analysis, it would have said so expressly, as have several other jurisdictions. Defendant argues that CPLA 30.10(4)(a) has only been applied to cases involving non-residents, relying principally on People v. Nobel, where a non-resident defendant remained continually outside of New York, which this court concluded thereby told the limitations period, adding that all periods of a day or more that a non-resident defendant is out of state should be tolded, and told the state in it is out of state should be tolded, and told the state. However, the Noble Court did not hold that CPLA 30.10(4)(a) is limited to non-residents, and the fact that Nobel and other courts have had occasion to apply the statute to non-residents is simply a consequence of the particular facts of those cases. Nor does the statute contain any requirement that the tolling period apply once authorities know that a crime has been committed, and, as with defendants' proposed exclusion for New York residents, we reject defendants' invitation to rewrite the statute to provide such limitation. We also reject defendants' contention that he was not continuously outside the state during his brief absences from New York. This argument is based in part on his erroneous and now squarely rejected interpretation that CPL 30.10(4)(a) should not apply to residents. To the extent defendant advocates for a lengthy temporal floor, Noble instructs to the contrary, as the court there held that all periods of a day or more during a defendant's absence from the state should be totaled and told the statute of limitations ID. Logically, then, even a day's absence counts. Moreover, defendant's absences would count even under his reading. He was outside of New York for a total of 200 days, including periods lasting up to 2 weeks. Defendant's policy arguments in support of his interpretation of the tolling provision are properly left to the legislature, the only body constitutionally authorized to enact and amend the statute. As the courts below properly concluded, defendant was outside of New York within the meaning of CPLA 30.10(4)(a) for a period of time that told the statute of limitations, and therefore the third-degree rape prosecution was timely commenced. Defendant argues that admission of the Molyneux witnesses' testimonies detailing sexual assaults he allegedly committed against them before and after the alleged offense conduct ran afoul of Molyneux and its progeny. We agree that this challenge has merit. Indeed, we reject the prosecution's theory, accepted by the appellate division and the dissenters here, that this testimony showed defendant's state of mind to use forcible compulsion against complainants and his understanding of their lack of consent. That analysis, if adopted, would eviscerate the time-tested rule against propensity evidence, which, in criminal cases, serves as a judicial bulwark against a guilty verdict based on supposition rather than proof, on collateral matters or because of a defendant's past, or on the defendant's bad character alone. People Valvino, in Molyneux, the court reaffirmed that the general rule of evidence applicable to criminal trials is that the state cannot prove against a defendant any crime not alleged in the indictment, either as a foundation for a separate punishment, or as a foundation for a separate punishment, or as aiding the proofs that they are guilty of the crime charged. The purpose of the rule is simple. Evidence of a defendant's uncharged crimes or prior misconduct is not admissible if it cannot logically be connected to some specific material issue in the case, and tends only to demonstrate the defendant's propensity to commit the crime charged, People v. Denson. The rule is the product of that same humane and enlightened public spirit which, speaking through our common law, has decreed that every person charged with the commission of a crime shall be protected by the presumption of innocence until they have been proven guilty beyond a reasonable doubt, Molyneux. To illustrate the universal acceptance of the rule and the reasons upon which it rests, Molyneux quoted its earlier decisions and those of other state courts. For example, the Molyneux court noted, as far back as Coleman v. People, the court had explained, the general rule is against receiving evidence of another offense. A person cannot be convicted of one offense upon proof that they committed another, However persuasive in a moral point of view such evidence may be, it would be easier to believe a person guilty of one crime if it was known that they had committed another of a similar character, or, indeed, of any character. But the injustice of such a rule in courts of justice is apparent. It would lead to convictions, upon the particular charge made, by proof of other acts in no way connected with it, and to uniting evidence of several offenses to produce conviction for a single one. The court also observed that, the following decade in People v. Sharp, Judge Peckham observed in a separate opinion that the general rule is that when a person is put upon trial for one offense, they are to be convicted, if at all, by evidence which shows that they are guilty of that offense alone, and that under ordinary circumstances, of are guilty of that offences in their lotianis toem fees, and their fingis in the rarest door of other offences in their less intimacy and stalayer sheener. The Molyneux court recalled that, a few years later, Judge Peckham authored the majority opinion in People v. Shia, explaining the impropriety of giving evidence showing that the accused had been guilty of other crimes merely for the purpose of thereby inferring their guilt of the crime for which they are on trial may be said to have been assumed and consistently maintained by the English courts ever since the common law has itself been in existence. Two antagonistic methods for the judicial investigation of crime and the conduct of criminal trials have existed for many years. One of these methods favors this kind of evidence in order that the tribunal which is engaged in the trial of the accused may have the benefit of the light to be derived from a record of their whole past life, their tendencies, their nature, their associates, their practices, and, in fine, all the facts which go to make up the life of a human being. This is the method which is pursued in France, and it is claimed that entire justice is more apt to be done where such course is pursued than where it is omitted. The common law of England, however, has adopted another and, so far as the party accused is concerned, a much more merciful doctrine. By that law, the criminal is to be presumed innocent until their guilt is made to appear, beyond a reasonable doubt, to a jury of 12. In order to prove their guilt, it is not permitted to show their former character or to prove their guilt of other crimes, merely for the purpose of raising a presumption that they who would commit them would be more apt to commit the crime in question. The Molyneux court also cited cases from Massachusetts and Pennsylvania that were to a similar effect, Commonwealth v. Jackson, noting the general rule that limits the trial to the immediate act for which the defendant is indicted. Schaffner v. Commonwealth, it is a general rule that a distinct crime, connected with that laid in the indictment, cannot be given in evidence against a prisoner. It is not proper to raise a presumption of guilt on the ground that having committed one crime, the depravity it exhibits makes it likely they would commit another. Molyneux recognized exceptions by which evidence of other crimes could be used to prove the charged crime when such evidence tends to establish 1. Motive, 2. Intent, 3. The absence of mistake or accident, 4. A common scheme or plan embracing the commission of two or more crimes so related to each other that proof of one tends to establish the others, and 5. The entity of the periniter at the authority of the acre the pamarity was to the. Although this list is not exhaustive, the court's Molyneux jurisprudence begins with the premise that uncharged crimes are inadmissible and, from there, carves out exceptions. In order to be admissible, Molyneux evidence must logically be connected to some specific material issue in the case and be directly relevant to it. Cass. The prosecution has the burden of showing this direct relevance. See Denson, citing Cass. In other words, evidence of a defendant's uncharged crimes or prior misconduct is not admissible if it cannot logically be connected to some specific material issue in the case, and tends only to demonstrate the defendant's propensity to commit the crime charged. Denson. When the proffered Molyneux evidence is relevant to some material fact in the case, other than the defendant's propensity to commit the crime charged, it is not to be excluded merely because it shows that the defendant had committed other crimes. In reviewing the Molyneux ruling, the court engages in a two-step process. First, it evaluates whether the prosecution has identified some issue other than mere criminal propensity to which the evidence is relevant. People v. Huddy. This is a question of law, not discretion, and we review it de novo. People v. Telfair. Second, if the evidence is relevant to an issue aside from propensity, the court determines whether its probative value exceeds the potential for prejudice resulting to the defendant, Alvino. At this step, the trial court's decision to admit the evidence may not be disturbed simply because a contrary determination could have been made or would have been reasonable. Rather, it must constitute an abuse of discretion as a matter of law. People v. Morris. However, any substantial doubt regarding how to strike a neat balance between possible prejudice to the defendant and indispensability of the challenged evidence to the prosecution's case should weight the scales in favor of the defendant AP standard. If the court concludes that the trial court abused its discretion by admitting Molyneux evidence, the court must determine whether the error was harmless or requires a new trial. CH People v. Leonard. The Molyneux ruling here fails at step 1. The trial court admitted the evidence to show defendant's forcible intent when he had sexual relations with complainants, rebut his claim of consent, and explain why complainants were hesitant to report these assaults. The prosecution argues that the unusual nature of the entertainment industry, and defendant's then outsized role in it, popular misconceptions about the behavior of sexual assault victims, and the complainant's acceptance of favors from him and, in one case, their continued consensual sexual relations with defendant following the assault rendered their testimonies equivocal on the issue of defendant's intent. Thus, the prosecution contends, the trial court properly admitted the 3 Molyneux witnesses' testimonies to show his unlawful intent. We disagree and conclude that, as a matter of law, the trial court erroneously held that the prosecution showed that the Molyneux witnesses' testimonies were necessary for a non-propensity purpose. See Huddy. First, the complainant's respective testimonies were not equivocal on the issue of consent. Complainant described a violent, forcible sexual assault, as well as her efforts to resist by kicking and pushing defendant. Complainant B testified that defendant physically blocked her attempt to leave the hotel room in March 2013, and that, when she did not comply with his demand that she undress, he grabbed her hand to force compliance. Complainant C testified that defendant lunged at her and that, when she tried to walk away, defendant used his weight to lead her to the bedroom where she fell backward onto the bed. She tried to leave, but he pushed her back. She kicked and pushed to get away, but defendant used physical force to hold her down with her hands above her head and then forced himself on her as she cried and continued to say no. There is no equivocality regarding consent when a person says no to a sexual encounter, tries to leave, and attempts to physically resist their attacker before succumbing to the attacker's brute physical force. No reasonable person would understand such behavior as having communicated anything other than their rejection of sexual activity. Indeed, a contrary proposition perversely turns the concept of consent on its head. Simply put, there is nothing consensual about the conduct complainants described. Thus, even though the prosecution contends, and the appellate division agreed, that the jury could believe complainants' recollections of the sexual attacks yet still believe that defendant thought they were consenting to the sex, we conclude that such is inconceivable. Complainants' descriptions of events belie any such equivocation in the moment. Nor did the fact that complainants maintained relationships with defendant, some sexual before and after the alleged assaults giving rise to the instant charges necessitate introduction of the Molyneux witnesses to show defendant's forcible intent. As the court has explained, where the crime requires the prosecution to prove forcible compulsion, the intent required is the intent to perform the prohibited act, i.e. the intent to forcibly compel another to engage in the sexual act, People v. Williams. And, when it comes to Molyneux, evidence sought to be introduced to prove a defendant's intention in the crime charged. The probative balance has generally warranted admission of this evidence only where the acts involved in the crimes charged are equivocal so that intention is not easily inferred from the acts alone, People v. McKinney. In other words, evidence of prior criminal acts to prove intent will often be unnecessary, and therefore should be precluded even though marginally relevant, where intent may be easily inferred from the commission of the act itself, Alvino. Here, this proposed basis for admitting the Molyneux witnesses' testimonies is a candid acknowledgement that the true purpose of this evidence was to bolster complainants' credibilities by showing that others behaved similarly towards defendant even after he made unwanted sexual demands. Of course, this is an impermissible propensity purpose, and the trial court therefore should not have admitted the evidence. See Molyneux. In reaching this legal conclusion, we take no step backwards from recent advances in our understanding of how sex crimes are perpetrated and why victims sometimes respond in seemingly counterintuitive ways. Canetaro dissenting op. 2. And we do not shut our eyes to the enduring effect of rape culture on notions of consent. And intent singis op. 10 as the respected disincent, and intent sing op. 10 as the respected disincent. On the contrary, consistent with our judicial role, our analysis is grounded on bedrock principles of evidence and the defendant's constitutional right to the presumption of innocence and a fair trial. Judge Singhas would ignore these principles because, In her view, they fail to account for how rape myths distort jurors' perceptions of victims and corrupt the deliberative process, CID. At 9:18. But justice for sexual assault victims is not incompatible with well-established rules of evidence designed to ensure that criminal convictions result only from the illegal conduct charged. Indeed, just as rape myths may impact the trier of fact's deliberative process, propensity evidence has a bias-inducing effect on jurors and tends to undermine the truth-seeking function of trials. Thus, when we limit Molyneux or other propensity evidence, we do so for policy reasons, due to fear of the jury's human tendency to more readily believe in the guilt of an accused person when it is known or suspected that they have previously committed a similar crime. People v. Brewer, quoting People Ventimiglia, citing Molyneux. And while the Molyneux rule addresses jurors' reliance on propensity evidence, contrary to the dissenter's suggestion, we have a means to address jurors' possible disinclination to believe sexual assault victims who act in ways that appear contrary to the jurors' experiences or views. See Kinataro J. Dissenting Op. at 6-8 Singays, Dissenting Op. at 6-8 AK at 2021. The proper method for dispelling rape myths in nuanced and complex cases, Singas J. Dissenting Op. at 24, is the one deployed by the prosecution here. Educating jurors about rape myths and social misperceptions about sexual assault with expert testimony explaining rape trauma and survivor responses, see Taylor. Specifically, testimony from the prosecution's expert provided non-propensity evidence that addressed what some jurors might have seen as counterintuitive acts by complainants when they continued to interact with defendant and contextualized conduct associated with rape trauma. As the expert explained to the jury, her professional work with sexual assault victims led her to conclude that many victims often maintain contact with their attackers out of fear the attacker will retaliate. That testimony was particularly crucial here. Judge Singas asserts that this court's decision will have adverse effects on other prosecutions. She claims, for example, that instances in which a trafficker repeatedly leverages workers' undocumented status to coerce them into sex, or a restaurant manager withholds tips from his employees unless they perform sexual acts will become a series of individual credibility contests and unrelated misunderstandings and stays, Dissenting Op. at 23. However, cases involving such repeated conduct likely would feature, much like this case did, direct evidence in the form of testimony from multiple complainants. Judge Singas assumes, with no empirical data, that few such cases involve evidence aside from victim testimony. In fact, many trafficking cases feature much more than that. Ch. People v. Lamb, summarizing sex trafficking case featuring evidence of online advertisements, phone records, emails, and photographs of unconscious victims, in addition to victim testimony. The Molyneux rule has not and will not, based on its application to this appeal, present an obstacle to prosecution of such cases, notwithstanding Judge Singas's exaggerated claims to the contrary. Moreover, this was not a single victim prosecution where there arguably is a heightened risk that rape myths could impair the jury's fact-finding and credibility determinations. Instead, 3 complainants testified to defendants' violent actions on different occasions, years apart, and how they behaved toward him long afterwards. There also were significant differences between complainants and the Molyneux witnesses. All 3 complainants had long-term relationships with defendant, whereas the Molyneux witnesses each interacted with defendant for brief periods. And complainant B explained that she maintained a consensual sexual relationship with defendant following the alleged criminal conduct, whereas none of the Molyneux witnesses testified about consensual sex with defendant at all. Nor, as the prosecution contends, did the unusual nature of the entertainment industry and defendant's stature within it require admission of the Molyneux witnesses' testimonies to show defendant's forcible intent or awareness of complaint's lack of consent during the alleged crimes. According to this argument, defendant might have thought complainants consented in order to advance their careers. The argument has a historical basis. The casting couch, where, as the story goes, aspiring actresses had to trade sexual favors in order to win roles, has been a familiar image in Hollywood since the advent of the studio system in the 1922s and 30s. Over time, the phrase has become emblematic of the way that sexual aggression has been normalized in an industry dominated by powerful men. Ben Zimmer, Casting Couch, The Origins of a Pernicious Hollywood Cliché, The Atlantic. This perverse quid pro quo unwanted sexual relations imposed by superiors on subordinates at work, however, is not unique to the entertainment industry and is centuries old. Revia B. Siegel. A Short History of Sexual Harassment in Catherine A. Mackinnon. Directions in Sexual Harassment Law. Within such a dynamic, an employer, supervisor, executive, or coworker with some power either offers to help or agrees not to hinder a victim's career, a historical reality especially for women because of the historical subjugation of women and their exclusion from positions of influence and power. See Marion Crane and Ken Matheny, Sexual Harassment and Solidarity, QA Prue Hasmond, and Solidarity, Q. Crew Hasmond. Occurs when a supervisor with the power to grant job-related rewards or impose discipline conditions the receipt of the reward or threatens discipline contingent on the victim's willingness to confer sexual favors, e.g., leap with me, and I'll promote you, or sleep with me, or I'll fire you, I'd. At 74M, watch gender-based harassment, especially hostile work environment harassment, is not driven by sexual desire and may not even be sexual in content. Instead, it takes the form of undermining women's competence to perform their jobs. Sexual harassment claims of abusive work environment under Title VIAQ quid pro quo sexual harassment is harassment that forces an employee to choose between acceding to sexual demands or forfeiting job benefits, continued employment, or promotion. But this is all irrelevant to whether defendant intended to use force during the course of the alleged offense conduct. See Williams. Here, complainants testified that defendant used force and, thus, his intent to commit the crime would have been established if the jury believed their accounts and concluded that force was used. But the Molyneux witnesses' prior experiences with defendant had no bearing on whether defendant used force against complainants. Testimonies from 3 individuals about their own unwanted sexual encounters with defendant were therefore unnecessary, Alvino. Instead, the testimony served to persuade the jury that, if he had attempted to coerce those 3 witnesses into non-consensual sex, then he did the same to the victims on the dates and under the circumstances as charged. That is pure propensity evidence, and it is inadmissible against a criminal defendant under Molyneux and its century-old progeny, see Hootie. This case bears some noteworthy similarities to People v. Vargas. There, the complainant told the police that the defendant followed her into her apartment building and dragged her to the rooftop where he raped and sodomized her. She testified that, thinking it would later facilitate his apprehension, she exchanged phone numbers with the defendant and agreed to meet him the next day at his apartment, where she had consensual sex with him. The defendant told police that he met the victim in the neighborhood and that she took him to the rooftop of her apartment building, where they had consensual sex. The trial court ruled that, given the defendant's consent defense, the prosecution could, under Molyneux, present testimony from 4 other women that the defendant had committed sexual misconduct against them, and in response, the defendant abandoned his consent defense and a jury later convicted him on a host of counts, including first-degree rape, CL, so People Vargas. This court reversed his conviction on various sexual offenses, holding that the trial court wrongly admitted the testimonies of the other women to show the defendant's intent. The court's analysis there applies with equal force here. 2 starkly contrasting scenarios were presented, with only credibility an issue. If the trier of fact believed defendant's version of events, complainant consented to a sexual encounter with him on the night of February 22, 1992. If the trier of fact found complainant more credible, defendant used force and threats to rape her, with intent readily inferable from the acts alleged. As in Hootie, the prior misconduct evidence was relevant only to lend credibility to complainant by suggesting that, because defendant had engaged in sexual misconduct with others, he was likely to have committed the acts charged. The evidence therefore was improperly ruled admissible. Judge Singh's attempts to distinguish Vargas because that case involved a stranger rape and chides us for not doing the same. Singh's, J. Dissenting Op. at 7:15. Here, of course, we engage in a straightforward analysis that applies Vargas's animating legal principles. Thus, it is Judge Singh's, not this court, who misses the relevant point that here, as in Vargas, defendant's intent was easily inferred from the commission of the acts themselves, as recounted by complainants in a case that boiled down to a credibility contest for the jury to evaluate. In sum, we conclude that the testimony from the Molyneux witnesses was unnecessary to establish defendant's intent and served only to establish defendant's propensity to commit the crimes charged. Neither the prosecution nor the trial court identified some issue, other than mere criminal propensity, to which the evidence is relevant, Hootie, and therefore its admission during the prosecution's case, in chief, was error. Defendant also claims that the trial court Sandoval ruling violated his right to testify. For the reasons we discussed below, the trial court abused its discretion when it ruled that defendant, who had no criminal history, could be cross-examined about prior, uncharged, alleged bad acts and despicable behavior, which was immaterial to his in-court credibility, and which served no purpose other than to display for the jury defendant's loathsome character. The ruling necessarily and impermissibly impacted defendant's decision whether to take the stand in his defense and thus undermine the fact-finding process in this case, which turned on the credibility of the parties. Under Sandoval, a trial court may make an advance ruling as to the use by the prosecution of prior convictions or proof of the prior commission of specific criminal, vicious, or immoral acts for the purpose of impeaching a defendant's credibility. When evidence of other crimes has no purpose other than to show that a defendant is of a criminal bent or character and thus likely to have committed the crime charged, it should be excluded, People v. Schwartzman. The trial court must strike a balance between the probative worth of evidence of prior specific criminal, vicious, or immoral acts on the issue of the defendant's credibility on the one hand, and on the other the risk of unfair prejudice to the defendant, measured both by the impact of such evidence if it is admitted after their testimony and by the effect its probable introduction may have by the effectanturi and by the offenders may fake chimperwinchuani. This category of evidence will always be detrimental to the defendant and will have a propensity to influence the jury or the court. Thus, to ensure that the defendant is not deprived of a fair trial, the court must consider whether the evidence will have a disproportionate and improper impact on the triers of fact, and undesirably deter the defendant from taking the stand and thereby deny the jury or the court significant material evidence. In weighing prejudice to the defendant's right to a fair trial, an important consideration may be the effect on the validity of the fact-finding process if the defendant does not testify out of fear of the impact of the impeachment testimony for reasons other than its direct effect on their credibility, as where the defendant would be the only available source of material testimony in support of the only available source of material testimony in support of the sword. We review Sandoval determinations for abuse of discretion. See People v. Walker. Prior crimes and vicious and immoral conduct evidence includes that which shows a willingness or disposition on the part of the particular defendant voluntarily to place the advancement of their individual self-interest ahead of principle or of the interests of society, because such proof may be relevant to suggest the defendant's readiness to do so again on the witness stand. Sandoval. In other words, even if the evidence did not necessarily involve an act of dishonesty like perjury, fraud, bribery, and similar offenses, evidence that the defendant committed a ruthless act voluntarily and deliberately supports the notion that the defendant may well disregard an oath and resort to perjury if they believe that to be in their self-interest, people eviennent. This basis for admitting Sandoval evidence is, by its terms, broad and vague. Accordingly, courts must be judicious in resting Sandoval rulings upon it, lest acts of common selfishness lead to mini-trials on the defendant's character that distract the jury from the crimes charged. The question for trial courts at all times is whether the evidence shows the defendant's lack of in-court veracity. Sandoval. If so, the evidence may be admitted, but only if not unduly prejudicial, for the limited purpose of attacking credibility. Here, the trial court's Sandoval ruling, to the extent it permitted the prosecution to cross-examine defendant about bullying and fits of anger towards employees, restaurant workers, and business associates, was an abuse of discretion. Defendant had no criminal history. Many of the acts approved for cross-examination by the court were not criminal in nature and had little if any probative value as to defendant's lack of in-court veracity, while also prejudicing the jury against defendant. Far in excess of what Sandoval and its progeny allow, the court ruled that the prosecution could ask defendant details about whether he allegedly, verbally abused an employee and also threw food at another worker, bullied, overworked, and verbally abused his personal assistant, pulled out of business deals, threw staplers and other objects at people, punched his brother at a business deals, threw staplers and other objects at people, punched his brother at a business meeting, threatened his was exuized in restaurant. Without question, this is appalling, shameful, repulsive conduct that could only diminish defendant's character before the jury. But Sandoval does not legitimize destroying a defendant's character under the guise of prosecutorial need. Quite to the contrary, because trial courts have a responsibility to carefully balance the prosecution's interest in attacking the defendant's credibility against the defendant's constitutional rights to a fair trial and to testify on their own behalf. Judge Canataro attempts to cast our correction of this piece of the Sandoval ruling as a byproduct of a general disagreement with the ultimate outcome of the trial court's discretionary balancing determination. Canataro J. dissenting op. 1011, quoting Walker. The nuance of our holding, which actually leaves much of the trial court's Sandoval determination intact, is more than enough to show that he is mistaken. This is not a case where the trial court might have been more discriminating but was nonetheless within its discretion. Walker. Rather, the trial court here abused its discretion as a matter of law when it ruled that the prosecution could cross-examine defendant on a broad swath of uncharged misconduct that did not bear on his credibility, far from inverting Sandoval, as Judge Canataro charges, Canataro, J., dissenting Op. 12. We heed it in its original form and apply it straightforwardly to rectify a branch of a ruling that necessarily undesirably deterred the defendant from taking the stand and thereby denied the jury. Significant material evidence, Sandoval. The Molyneux and Sandoval rulings had a synergistic effect that deprived defendant of his right to a fair trial. This was a case, like many other sexual assault prosecutions, where the complainant and the defendant are the only ones who know for certain what happened. Here, the Molyneux witness's testimony bolstered complainant's testimony, thereby impacting the jury's credibility determination. As the appellate division observed, the evidence of uncharged acts would show that defendant demanded sexual favors from aspiring female actors in return for promises of help with their careers, regardless of their agreement to this quid pro quo. The testimony of the three Molyneux witnesses, although framed as evidence of defendant's intent to use forcible compulsion and his awareness of the victim's lack of consent, was, in courtroom reality, evidence of his propensity to commit the crimes charged. This was not the sole error of constitutional dimension. The erroneous Sandoval ruling allowing the prosecution to cross-examine defendant about allegations of charged and uncharged bad acts was breathtakingly inclusive of behavior that was loathsome but not the type of conduct that would assist the jury in measuring his credibility on the stand. The ruling thus served to discourage defendant from exercising his rights to present a defense and testify on his behalf. Together, these errors deprived defendant of the self-standing constitutional right to a fair trial, and proof of guilt, however overwhelming, can never be permitted to negate this right. People v. Crimmins, see also Estelle, even if that were not the case, and if we assumed that these errors were subject to our non-constitutional harmless error analysis, we would not deem them harmless. A Molyneux error may be found harmless where the proof of the defendant's guilt, without reference to the error, is overwhelming, and where there is no significant probability. That the jury would have acquitted the defendant had it not been for the error. People v. Arafat, quoting Crimmins. The standard applied to non-constitutional Sandoval errors is substantively the same. See People v. Grant. Finally, in assessing harmless error, the court considers all trial errors cumulatively. People v. Wing. Here, the whole case turned on a very close question of credibility. The core choice the jury had to make was whether to believe the complainant's respective versions of events. People v. Williamson, cf. Ben v. Greiner reversing habeas grant because the case did not present a, he said, she said, scenario of two persons, one of whom claimed a sexual encounter was consensual and the other of whom claimed it was not, a scenario in which the exclusion of cross-examination regarding past unverified accusations might well have contributed to the jury verdict in a substantial and injurious way. Moreover, the jury had to consider evidence that, both before and after the alleged offense conduct, complainants were outwardly friendly with defendant and maintained personal contacts, and in the case of complainant B, a years-long relationship that included consensual sex. The jury then had to weigh this evidence against defendant's expert evidence about the effects of trauma on memory and the prosecution's expert's testimony that, contrary to public misperceptions about how credible victims respond, sexual assault survivors often exhibit this same behavior. Even if we were to regard the evidence against defendant as overwhelming, there remains a significant probability that, absent the trial court's erroneous Molyneux ruling, the jury would have acquitted the defendant, Arafat, quoting Crimmins. And, though harmless, error analysis in the context of Sandoval does not involve speculation as to whether a defendant would have testified if the legal error had not occurred, Grant, quoting People v. Williams, the erroneous Sandoval determination here might have affected defendant's decision whether to testify and provide critical information, Williams. Thus, neither error was harmless. How different is our own common law, which is the product of all the wisdom and humanity of all the ages. Under it, the accused comes into a court of justice, panoplied in the presumption of innocence, which shields them until their guilt is established beyond a reasonable doubt. Their character can be thrown into the balance by no one but themselves. The incidents of their life, not connected with the crime charged, are their sacred possession. They face their accuser in the light of a distinct charge, with the assurance that no other will be, or can be, proved against them. Lie new. These words are no less true and vital today as they were when first written by this court in 1901. Over a century later, we reaffirm that no person accused of illegality may be judged on proof of illegality may be judged on proof of uncharged crimes that serve only to establish the accused's propensity for criminal behavior. At trial, a defendant stands to account for the crimes as charged. Proof of prior crimes and uncharged bad acts are the rare exception to this fundamental rule of criminal law. Similarly, under Sandoval, cross-examination of the defendant with allegations concerning prior convictions or proof of prior specific criminal, vicious, or immoral acts is impermissible except to the extent it bears on the defendant's credibility. Thus, it is an abuse of judicial discretion to permit untested allegations of nothing more than bad behavior that destroys a defendant's character, but sheds no light on their credibility as related to the criminal charges lodged against them. The trial court's rulings ran afoul of these time-honored rules of evidence. Accordingly, the order of the appellate division should be reversed, and a new trial ordered. Order reversed and a new trial ordered. Opinion by Judge Rivera. Chief Judge Wilson and Judges Barros and Clark concur. Judge Singa's dissents in an opinion, in which Judges Garcia and Canataro concurred. Judge Canataro dissents in a separate dissenting opinion, in which Judges Garcia and Singas concur. Judges Troutman and Halligan took no part.
Decision podcasts are brought to you by the New York Prosecutors Training Institute. Find this and other decisions at NYPTI Law. www.nypti.org/law